I love it when I get good questions. We've got one today, and we're going to go over it. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. If you have a question about something and you need to provide context, the easiest way to get a hold of me is through the Gmail address. It's always at the end of every video. You can go there and find it. And that's what somebody did yesterday evening. They sent me an email with a particularly interesting question. I keep hearing that the prosecution in the Daybell trial is getting away with asking a lot of leading questions. I was also sure I'd heard that one side or the other was allowed to ask leading questions, but I don't know if that was on direct, cross, or redirect. I'd really appreciate it if you could use some of the leading questions in the Daybell trial to show us why they are considered leading, and if there are times that leading questions are allowed. You explaining that would be an added bonus. I also sometimes wonder if Lori isn't objecting because she may be able to use these as a basis for appeal. Well, let me answer that last question first. If you make a mistake in trial and you don't do something that the law requires that you do, like object, you don't have a leg to stand on in appeal. The law does not rescue you from your own misconduct or your own error in a trial. In fact, there is a doctrine of invited error, meaning that if you tell the judge you want to admit an item and then later on it turns out to harm your case, you can't claim that it's error because you invited that error. So, no, Lori may very well think that that gives her grounds for appeal because she clearly doesn't understand the way the legal system works, but it's not a get out of jail free card. Not that she's ever going to get out of jail free or otherwise, but it's not something that's going to help her in this case. Now let's deal with the issue of leading questions. A leading question, as I've said on here several times, is a question that essentially gives you the answer in the question. You were looking left, not right, correct? Yeah, I was looking left. If you give the person the answer in the question, the witness isn't testifying, the lawyer is. And so, on direct examination, in other words, for the party that has the burden of proof, you cannot examine a witness with leading questions. But the other side of that coin is that you absolutely have to object to that when it happens. I've selected a few examples here of leading questions from day 5 of the trial when the state was examining the detective who testified. Let's watch those.
When you got there, was the fire engine still there?
I believe they were, but there was a, what we call our care unit. Our CR 288 is the crisis unit. They're a fire personnel, but they respond out to our scenes at our request as well.
While you were on scene, did you notice any other civilians kind of waiting around?
Yes.
So did Officer Krautheim advise you and other detectives who they were?
Yes.
So you said the female was Lori Vallow?
Correct.
During this time, did it become known to you the relationship between Lori Vallow and Alex Cox?
Correct. They were brother
The
sister.
first question about the fire engine being there, well, that was the better objection would have been to Black's Foundation, but in this particular case, it would be proper to object to that as a leading question because it can be answered yes or no. And as a result of that, since it suggests the answer, is it yes or is it no, you have a situation where, again, the lawyer is testifying. The next question, did you notice any other civilians waiting around? Again, it can be answered yes. Now, in some respects, this is foundational, and a judge might not sustain an objection here, but it clearly is a leading question. A better way for the prosecutor to have asked that question is, what did you notice about people in the area of the crime scene? And now your witness has an opportunity to tell you what she saw, and it's not a leading question. Using the framework I've just provided you, you can tell that the remaining questions about Officer Krautheim and others were clearly leading questions, and Lori Daybell did not object to a single one of them. So all the evidence that came in through those leading questions is going into the record unchallenged, meaning she didn't do her job as defense counsel. But this is very common when you don't understand the rules or the system. Now, again, the state has the burden of proof, so they have to examine with direct questions, open ended questions that do not suggest the answer. And if they ask a leading question and it's objected to, in most cases, that objection is sustained. Lawyers, when they are litigating cases, generally don't object to foundational questions. You were the first one on the scene, correct? Yes, I was the first one on the scene. Does that matter in the grand scheme of things? Is it the aha moment or the Perry Mason moment? No, of course not. And so it's not going to hurt you. You don't object. You let the other lawyer try his case. In other words, you don't require, you know, you don't make objections that are really kind of mindless. And you really help yourself with the jury when you don't do that, because if you have to go back, if they have to go back and use non-leading questions, it just takes longer. Not to mention it throws the other party off of their game, and sometimes it's necessary to do that. I guess as a strategic method, but I don't personally like it, and I don't like it when it's done to me, so I don't do it to other people. Now, on the other hand, Lori Daybell, she is cross-examining this detective on day 6, and she has lots of opportunities here to ask leading questions. Let's look at the first one.
Okay. Did you look to see if the threatening text messages from Charles did actually exist?
I did not do an exam of the phone.
At this point, Lori should know that she didn't do an exam of the phone because she's got all of the state's exhibits and all of the state's evidence that's already been handed to her. She knows what this detective put in her report, so she knows that. And of course, because it's an open-ended question, instead of answering yes or no, she says what she says. I didn't examine the phones.
Yesterday, we watched the clip of my interview with you, and we discussed the threatening text messages. Is that correct?
Correct, you told me about them.
And you stated that I did not show them to you. Is that correct?
You did not show them to me, no.
And did you ask me to show them to you?
I did not.
Had I been cooperative all that day?
Yes,
Do you think I would have shown them to you if you would have asked me?
Objection, speculation.
Sustained.
Was Tylee also cooperative that day?
I believe so.
Here again, to be impactful, she should have used leading questions. In our interview, we discussed the threatening text messages, right? Right. I was cooperative with you, right? Tylee was cooperative, right? We weren't anything but cooperative, correct? And you didn't have a problem with us answering your questions, right? We didn't evade any question, did we? No. Again, leading questions. You move fast and you score points and you impress the jury that you are being efficient with the time.
Was Alex cooperative that day
I don't know. I did not have contact with Alex.
at all?
I did not interview him or talk to him, no.
Did I, in fact, inform you during that interview that I would have to show you them to explain them?
I believe so.
But you never asked me to show them to you?
I did not.
She starts out blundering there, asking questions she doesn't know the answer to about Alex, but then she does ask a couple of pertinent questions. But she asks them in that open ended way, which deprives them of the force. I told you I'd have to show you those text messages in order for you to understand them, right? Yes, that's what you said. and you didn't ask to see them, correct? Right. You didn't ask to see them then, period. You didn't ask to see them later. What you do there is you make the point very clearly that this detective didn't do her job. Again, she's making mistakes because she doesn't know the process.
In the course of your investigation, did you ever, in fact, see those threatening messages from Charles to me?
I did not. I did not look at any of the downloads of any of the
Now,
files.
that was actually a pretty good setup question, but it requires the appropriate follow up in order to maximize the impact of it. You knew those text messages were there, you knew they were important, you didn't ask to see them. They obviously played a role in how things developed, and yet you ignored them. Why did you ignore those messages? And what would probably happen there is the state would object as argumentative, particularly if you ask it as, why didn't you do your job? Which would have been a much more effective way to ask it. And then when the state objects, you say, I'll withdraw the question. Because again, in this situation, it is not the answer to the question that matters, it's the question. That's the same question the jury has. Gosh, why didn't she go look at those messages? In her own kind of klutzy way, she is sort of getting to that point. But the reason you use these leading questions is so that you make the point and you do it repeatedly without drawing the asked and answered objection, because each time you change the question just a little bit. At this point, she just continues to blunder through this examination. And it's really kind of painful to watch because a lot of times, well, one of the courses that you can take in law school that actually I didn't take, but probably should have, is called trial advocacy. And the way they teach this class is they bring in actual trial lawyers who try cases, a lot of times prosecutors, public defenders, that kind of thing. And they use them as opposing counsel for the person who is trying to put on a witness in this mock trial that they're doing in trial advocacy. And so they ask a question like that, and you'll get an objection. And you have to figure out how to get around that objection in order to get the evidence in. And people break down in tears thinking they are never going to be a lawyer because this is just so hard. So, in some respects, I have a little bit of compassion. Maybe, if it was measured, it would be like a billionth of a gram for Lori here because she's in an area where she knows absolutely nothing about how to proceed. And that's the inherent danger in being your own lawyer. The inherent danger is that you get up there and you blunder around, and oftentimes you wind up sinking your own ship because you just don't know where to put the mast. That's a sad thing, and it particularly when you're dealing with somebody's freedom, is it sad. But in this case, again, it probably doesn't matter because she's going to be locked up for life in Idaho no matter what she does. And yes, I understand that there is an appeal, but courts and appellate courts also understand that there is a situation where a trial court makes an error that maybe in a robbery case or a simple assault case they might reverse. In a situation where there is so much evidence that points directly to this defendant, as there was in Idaho, they're not going to reverse the judgment. They're going to call it harmless error because there was such a huge quantum of evidence that pointed to her, and her behavior in the days, hours, weeks, and months after the crime was committed so clearly was evidence of guilt. It is a difficult thing to act as your own lawyer. It's why nobody recommends that you do it. I have, upon occasion in small claims court, acted as my own lawyer, but I knew what I was doing. And also, in small claims court, the rules of evidence don't apply. So you can get in hearsay. You can get in the kinds of evidence that you can't possibly get in a court like this. It makes a big difference. So that's the answer to the leading question issue, right? The direct examination by the state, the party with the burden of proof has to be by open-ended questions. What were you doing? What did you see? Tell me about this. Tell me about that. Those sorts of things, open-ended questions that don't suggest the answer. The defense, or the party without the burden of proof, gets to come in and use leading questions. And make no mistake, when someone is using leading questions, they are testifying as surely as if they were sitting on the witness stand. In effect, it is the ventriloquist dummy syndrome. They are moving the mouth of the witness to say what they want the witness to say. That's important because the dynamic is such that you can really move things along, get stuff done quickly, and all of the rigmarole with laying foundation and establishing knowledge, moving into, you probably saw if you watched the initial part of the examination for the detective, she talked about her time on the force, her experience, what she was doing the day of the murder, how she got called to the scene, how she got there, what she saw. And all of that is necessary to lay a foundation. But all of that looks to the jury like you are wasting their time. She's a detective. Of course, she's going to be at the crime scene. But the law doesn't allow that. The law requires that the foundation be laid. So if Lori Daybell had gotten up there and said, "You didn't know anybody from anything when you got to the crime scene, did you?" Right. You didn't know who I was, correct? You didn't know who Tylee was? No, I didn't know that. And you didn't know what had happened inside the house, correct? Yes. The only thing you knew was that Charles was dead, right? And you were going to tell me about it, right? And I set you straight, didn't I? Yes, I set you straight because you didn't know anything. And in spite of that, you come at me saying that, you know, I am somehow inappropriately responding to this situation. Of course, that would have drawn an objection. But the important thing is that it hammers the witness and it doesn't give them any wiggle room. They have to answer the question yes or no. If they don't answer the question yes or no, Lori would have said, "That was not my question. My question is," you repeat the question. "That's a yes or no question, detective. What's the answer?" And if she again evades, you turn to the judge and say, "Judge, can you direct her to answer the question yes or no?" And again, sometimes not all questions can be answered yes or no. The judge might help you, the judge might not. But at the very least, you've made it look like you are trying to hold this detective to the truth, or at least confine her back within her ambit to the truth. Now, I think it's a good thing for justice in this case, maybe that she's not doing that she doesn't know these things. But I have to say, it is a dangerous proposition, as I said before, to ever do your own legal defense, and particularly in a murder case. Perry Mason wouldn't have done his own defense in a murder case. So I hope that answers the question. Let me know in the comments. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.